number 1 is a matter of mental hygiene legal service versus Sullivan. Counsel?
May it please the court. I am Shannon Stockwell of the Mental Hygiene Legal Service, appearing on behalf of petitioner DJ and MHLS in its agency capacity. I would like to reserve 2 minutes of my time for rebuttal, please.
You may, sir.
MHLS's ability to attend treatment planning meetings at mental hygiene facilities arises from Mental Hygiene Law, Article 47, and is further supported by Mental Hygiene Law, Section 2913.
So, counsel, under the statute, it is required that someone who is an authorized representative or a significant individual be interviewed and given an opportunity to participate in the planning of the treatment for the patient. What does the lawyer do in the context of planning the actual treatment to be delivered to the patient?
Sure. Well, certainly, it's our position that our ability to attend treatment planning meetings arises from our enabling statute, which provides us or authorizes us to provide legal services and assistance to patients and residents of mental hygiene facilities.
But the enabling statute, doesn't that envision a traditional attorney-client relationship?
Well, that's our job. You know, we are supposed to maintain an attorney-client relationship, a traditional one, to the extent that we're able. But MHLS is a very unique legal practice. We're lawyers and advocates. That was our role. We were created.
So let me see if I can build on the Chief's question, because I think while you're answering the question you want to answer, I don't think you really answered her question about what does the lawyer contribute at such a meeting. And so let me see if I can tease that out a bit. What happens if you get to the meeting? Let's say you are allowed to go, the lawyer from MHLS is allowed to go, and, you know, they want to give the patient Haldol or lithium, and the client doesn't really want to take these medicines because they don't like the side effects. They don't want to be drowsy, sleepy, whatever. Now, it seems to me that as the attorney, on the one hand, you would have some obligation to put forth that position when you get to the point of a hearing or, you know, wherever it's going to lead to. On the other hand, if you're planning treatment and you're trying to do what's in the welfare of the patient, that's a different role. And so I guess that's what I'm struggling with, and I think that may be underlying some of the Chief's concern.
Right. What does MHLS bring to the treatment planning table, so to speak?
Well, follow up with the judge's question. As Judge Feynman knows, and all of us have been trial judges know, one of the most common type of hearings you have with mental health issues is treatment over objections. Mm-hmm. And so the attorney has to play a particular role as an advocate that may be directly contrary to the role that a significant individual would play in developing a treatment plan. And that would seem to be because of the inherent difference in the nature of their functions. One deals with medical issues, and another one deals with advocating your legal rights, even though you might not necessarily agree with the assertion of those rights to the benefit of your treatment. And that's, I don't know, as a trial judge, that seemed to be one of the most common kind of determinations you were called on to make in these issues, in the treatment over objection issue.
Sure. Well, certainly in the context of a treatment planning meeting, if medication were to be discussed, and if we were aware that the client was objecting to a certain medication, we might also know that he's accepting of another medication. We would make that known to the treatment team.
Yeah, that would be great, as if you were his mother or wife or brother or sister or someone like that. But an attorney is going to come in and give medical advice?
It's not medical advice. I mean, we have, if our clients typically aren't new to the mental health system by the time they end up in a mental hygiene facility. They may have been on a multitude of medications over the years and have had a conversation with us. hey, Haldol's okay, but I do not want to be on XYZ medication
Sure.
because I've had a horrible
That makes
allergic
sense.
reaction to it over the years.
I have some trouble relying on the general provisions of Article 47 rather than the specific provisions of Article 29, particularly 2913B, and you know, they're just, I think, a variety of things in the context of the statute itself and the legislative history that would indicate that where the legislature sought or intended a role for MHLS in particular proceedings or events, it said so. It said so in 2915, for example, and there are other examples of that. But so when you look at and also Article 10, where it referred to 2913, it didn't refer to any role for MHLS, and 2913 doesn't specifically mention any role for MHLS. So I think when we look at the specific context, is what I'm saying is how do you find that role in the statute itself?
Well, both mental hygiene law, Article 47, and 2913, the treatment planning statute, are remedial statutes. I think that they're entitled to liberal construction. They're meant to protect the interests of disabled individuals. And certainly, mental hygiene law 4703 talks in terms of our general care and treatment advocacy
Counsel,
function.
let's talk about the exact language of these statutes. So 29.13, I just want to stay with the significant individual provision. That language there about the individual concerned with the welfare of the patient seems to me to almost mirror language that you find both in a general and specific provision, 4703C, and in, I think it's 29.15F. And in both of those provisions, it's very clear that the legislature is referring to that type of individual, the individual that falls in that category, being informed about MHLS and the rights of the patient. So given that our rules of construction require that we treat terms used in a statute similarly, strikes me that that means that the legislature did not intend, at least with the second part, let's just stay with the second part for the moment, of 29.13, right? To refer to MHLS as that individual concerned with the welfare of the patient.
Well, I think that when 2913 was amended in 1993, I believe, to include the term significant individual, if you look at the legislative history, the assemblymen that introduced that legislation specifically indicated that the intent was to allow patients to select any individual that's in his or her choosing. It doesn't
But wasn't the
accept-
purpose for those people who didn't have authorized representatives? Doesn't it also say that?
That's how significant individual came into being.
Right.
But certainly, Judge, I think we're losing sight of the fact that many of our clients have nobody in the entire world.
But all of your clients have MHLS. So if the purpose of a significant individual was for those people who didn't have an authorized representative or someone to advocate for them, right?
Yeah, I love the idea. I mean, if you're saying that, I mean, that's our argument. We need to be at the if there's no significant individual
No.
for the
I
person.
think
that's not
I
my
think in
point.
part what the point I think that a couple of us are trying to make is that MHLS is already a representative, right? This is about other categories of people for a particular purpose in that treatment plan conversation, whereas MHLS is serving another purpose, whether you look at it as a traditional attorney-client relationship, or perhaps you have others on staff who work in some other way with your clients. But I don't find where I think you were going with the response to my question very responsive, which is that I think you meant that the individual concerned with the welfare of the patient is exactly who you are, and therefore you fit this. My point is a statutory construction point, which is, that's not the way this language is used in the statute otherwise. And I don't see then how you can say we should read it differently for this provision, especially as Judge Stein points out, it seems not to really make sense to do
I
that.
think the problem with the courts construing MHLS out of the statute in terms of being a significant individual or authorized representative is that we're leaving these individuals potentially by themselves at the treatment planning
Well, that's a
table.
different story. One could read this as the entity MHLS is not what the legislature had in mind, but any particular staff member of MHLS not serving within that attorney-client relationship could very well fit this bill, especially with your example, a client who has a patient who has no one else.
I think that's hypothetically possible, but certainly the restrictions that OMH placed on one of our MHLS's attorneys serving as a significant individual in their private capacity would make them no longer be able to serve as an MHLS attorney. They had to swear that they would no longer be serving as an MHLS attorney for this individual. And
Is it not the best of both worlds? They have their MHLS attorney, and they can have a representative from MHLS who's in the room?
I don't think that model works in that we don't have the resources to assign an MHLS attorney for legal representation and an MHLS attorney in that discrete instance as the person's significant individual.
Need that? I guess that's part of the question here. Was the intention to have an attorney in there at all? I know that in the third department, MHLS is a little different than in the other departments, and we'll probably talk about that a little bit in the other cases. But some of the MHLSs have non-lawyer people who are a little bit more involved with, other issues other than legal issues. I'm not sure exactly where the line is drawn, but...
well, those are information officers, but they share information with their MHLS counterparts, so that doesn't fit OMH's demands with respect to putting up a barrier for in terms of information flowing back to the agency. So it's an imperfect example, the information officer. And in the third department, we don't employ any of them.
Thank you, counsel.
Thank you.
Counsel?
Your Honors, may it please the Court, Kathleen Treasurer for the respondents.
Counsel, what do you make of what do you make of this point that there are some patients who have no one else? The only person that they have some relationship with, that they would feel comfortable requesting in the room, is that MHLS attorney.
Well, 2 points, Your Honor. First of all, the third department correctly determined that an MHLS attorney could qualify as a significant individual if they could establish that they have the personal connection with the patient, such that they meet the definition of somebody.
How do they resolve their resource issue? They say we don't have the resources to do that.
Well, I think that is all the more why the legislature really didn't intend to have MHLS serving any role in the treatment planning process.
But the legislature and the history, of course, supports this. It makes it clear that they did want someone to be able to choose an advocate to be in the room with them who's not a close friend and who's not a relative, but someone who's concerned about their welfare.
That's right. And I think in most circumstances, what OMH would say is they welcome somebody being designated as a significant individual on behalf of the patient. They want that input. But it's different when it's somebody from MHLS and an attorney.
So are you saying that MHLS is not excluded from filling that role? It's just that they don't automatically have a right to be there as the MHLS attorney?
That is precisely the argument, Your Honor.
And then what is the role of that person then? Is it as an attorney, or is it as a person who is participating solely in the building of the treatment plan based on the mental health and getting that person better?
We would be looking for them to participate in the treatment plan as the significant individual, as a person interested in the welfare of the patient and looking at their clinical needs.
And then going on to represent their legal interests as well?
I think that the court can leave for another day. OMH has said in the letters in the record that they would ask that that person recuse themselves from being MHLS counsel for the person. And I think whether or not the conditions that OMH places on somebody at MHLS is acting as a significant individual is something that can be left for another day, and whether that's rational. The third department did that, and the court did that.
I just want to be clear. You're not advocating a blanket rule about no attorneys or no MHLS attorneys can serve as significant individuals. You really, it sounds to me, saying you have to look at this case by case.
It's a case-by-case basis. And also keep in mind, 2913B is the individuals who the facility must give an opportunity to participate.
So if that's the case, that it's a case-by-case analysis, isn't that just going to invite more litigation as opposed to some sort of clear-cut rule?
Well, I think that it has to be a case-by-case analysis because the commissioner and the facility are charged with taking care of the care and treatment of the individual, and they have to look at what are the facts here that support appointing this person as a significant individual. I just want to if I could just say this, Your Honor, MHLS here is asserting a blanket right. So that's what we're objecting to is that
I thought they were arguing that there's no blanket exclusion. I thought their point was that if the patient, their client, selects them, and we're just staying with the significant individual for the moment, that there's no reason that they cannot serve in that role. Whereas the facility and the AG now argues that no, they cannot serve in that role except under the circumstances in which they are not the MHLS attorney that represents that individual moving forward.
And unless they can also show that there's that personal connection.
Okay, so that's what I wanted to ask.
Yes.
Thank you. Now we're moving right along. So is your position that the facility gets to decide when a patient says, I choose him or her, whether or not the individual is concerned with the welfare of the patient?
What happens, again, Your Honor, I just want to be broad on this, is OMH and the facility's position is that for the most part, there's going to be a presumption that the person designated by the patient as the significant individual is a person who's appropriate to serve in that capacity, unless there's something in the clinical record to indicate that that person shouldn't serve, such as maybe they're the victim of the client or whatever.
Yes, okay.
But in cases where somebody is coming forward and saying, I want to participate as a significant individual as their attorney, that's a different situation, because really the only relationship they are pressing on OMH and the facility is the professional relationship that they have. I think you've changed a little bit
their argument. I thought their argument is the patient has chosen me as the individual concerned with the welfare of the patient. It's not a family member who's not a close friend. I also happen to be their lawyer. But they've chosen me to serve in this role, but I also happen to be their lawyer.
They've never explained what the basis for the significant, how it is that they qualify as the significant individual outside of their role as an attorney.
Do you ask them or do you ask the patient? The patient chose.
The patient chose, but the patient hasn't alleged anything outside the fact that the person is an attorney for them either.
But they've said, I want to choose them as a significant individual, right?
Right, and precisely because they're their attorney. In the affidavit that was submitted by DJ, that's what he said.
Yeah, but isn't the real-world implication is you're an isolated person with mental health problems in a psychiatric center. The only person you have contract with is an attorney. Sometimes you'll develop an actual personal relationship with that person, and you say, all right, you care about me, therefore I would like you to be the person at this treatment meeting that they have. And what the facility is saying in response is, that's fine if you want to be the significant individual, but you can't be both the attorney and the significant individual. And so that inherently, I see why you say it's a question for another day, but it must be on a case-by-case basis to look at it.
Right, Your Honor, that's exactly right. And they want to know what the basis, I mean, nobody said here, we've established this relationship over time.
Correct me if I'm wrong, but you're not arguing that an attorney cannot become a significant individual. What you're saying is you can't be both the attorney sitting in on a medical treatment meeting and a significant individual.
I think what I'm arguing is twofold. Okay. One is the attorney can be a significant individual, but we want to know what the basis for your being the significant individual is outside of asserting that you're just his counsel.
It's not just you, it's not enough that you care about me because you're my lawyer.
Right.
Is that what you're saying?
Exactly. We want to know that there's a personal interest.
So in this case, then the record would be incomplete on that issue.
Exactly.
Yeah.
That's exactly right. That's what we're arguing here.
So going back to Judge Rivera's question, and maybe we are going a little beyond this case, but we need to look at that. Who would make that decision? So if the patient says, this is my lawyer, he or she also has gotten to know me and is, and is the only person I have that I feel comfortable with who cares about me, and so then does the facility then make that determination? Well, yes, okay, there's enough, or no, there's not, or who
Well,
does
the facility would make it in the first instance, and then they would have, if it was denied for whatever reason, they would have Article 78 review, and if it was granted, then everybody would be
Wouldn't it almost essentially come down to, if you really want to serve in that role, you'll give up the other role as being an attorney?
That's what OMH, again, has said in the letters, but again, none of the courts below reached that issue. The other part that
I just have one question, just curious. If you had someone in this situation who had a personal attorney, they also happen to be friends with, and they make the same application to come in, what's the policy of the institution?
They're going to look at it the same way, and it's because what happens at the treatment planning meetings is very dependent on a solid therapeutic relationship between the treatment planning team and...
So you would say to a private attorney, give them the same essential choice? You can come as a significant other, or you can represent this person?
They would be looking at the relationship very carefully, because what they don't want to do is inject an adversarial tone in the treatment planning process.
Yeah, but that's a problem, because that's not the legislative history. The legislative history is very clear that the legislature wanted someone who could serve as an advocate. Now, it may be that the team doesn't want someone who disagrees with them, but that's not what the legislature said. It may very well be that the MHLS attorney is in complete agreement and is very helpful in moving the plan forward. But there's nothing to suggest, as is argued in these papers to this court, that this individual has to be on board with everything the team, recommends and persuade the patient to go along. That may be what is the hope, don't get me wrong. But an advocate could be one who disagrees and tries to push things in the other direction, and certainly being a family member or close friend doesn't mean you're going to support what the team recommends.
I don't disagree, Your Honor. Disagreement is not the issue. Disruption in the treatment planning process.
Well, why is there an assumption that that would be what would happen? That's my concern with the way this particular argument was put forward in the papers.
Because it has happened in the past, in that they had a 330-20 patient whom Gina McCormick, the treatment team leader, spoke about in her affidavit, where they had MHLS counsel come in and act on that person's behalf at the treatment planning meeting, only to turn around and then tell the patient not to cooperate anymore with the discharge planning process. Or
but that could be true of an individual who fits this bill. That could be true of the family member. That could be true of a close friend.
It could, but
there's no assurance is all I'm saying to you.
No, there's no assurance, but there's also more of a risk when you have somebody coming in and acting as their attorney that something like that's going to happen, particularly when they have the legal interests of the patient at stake. There is just one more thing I'd like to add to the court. For the court's consideration. This 2913B is who must be given a participation opportunity. It does not limit the commissioner or the director of the facility from considering people outside of this scope. If they come in and say, for example, DJ's alone, he would like me to act as his advocate, that there's something beneficial that I can do for him in the treatment planning process. There's nothing to prevent the director of the facility from considering that application and granting it as somebody outside of 2913B. 2913B is just who must be given that
Certainly sounds like what I think it was the commission had recommended, to try and get more people involved in this process. If that's better for the patient, better for society.
Right, and they're also going to look, but they are going to consider who it is that's making the application, whether or not they do think that person's going to be beneficial and offer valuable input to the process.
What if the patient says, I don't want them in the room?
want, then I think they have to leave. They can't participate.
It wouldn't be helpful to the process.
Well, it's also, keep in mind, it's the patient or the authorized representative, or if the patient's over the age of 16, it's the person that they request.
Well, I'm just talking about an adult patient. If someone,
Right.
as you've described, comes forward and says, you know, I think I can be helpful, this is what I could offer, I'd like to be in the room, and the patient says, I don't want them in the room.
Then we can't
Seems they
let them
can't
in. We
really do
can't-
what they hope.
We really can't let them in the room.
Right.
That's-
So, but if they say, I really, really want MHLS, my attorney, in the room, that's a different story.
It's different, it works a different dynamic with the treatment team, Your Honor, and they have to be very, very conscious of that in
What
order.
does that do to the dynamic to refuse the person they have chosen who clearly does have an interest in their welfare?
Well, we haven't had any problems that I'm aware of in terms of, even when we've allowed MHLS attorneys to participate, they haven't shown up. People have gone forward with the planning process without any problem. So I'm not sure that it really impacts. It also doesn't
So in those
prevent.
cases, when they've been allowed to participate, are they wearing the hat of the lawyer also?
I'm not sure that they are, Your Honor. I
So in the
don't know.
past, they have been allowed to sit in that room?
But they've been allowed to participate, maybe not as a significant individual, but as somebody else who can provide some help to the proceeding. And that's outside of 2913. What we're just saying here is there's no categorical right.
Thank you, counsel.
Thank you.
Counsel?
Just getting back to 2913 briefly, the statute talks about the participation of a significant individual who is any relative, close friend, or individual otherwise concerned with the welfare of the patient. That's MHLS, the last part. Otherwise concerned with the welfare of the patient. We have clearly an oversight role in terms of the care and treatment being offered at facilities, and we can commence any litigation necessary to protect our clients' right to be free from abuse and mistreatment. In terms of this scenario where an MHLS attorney would be participating in a treatment planning meeting as a significant individual, but no longer acting as an MHLS attorney, I think that scenario would be exceedingly rare. I don't think that even if a client or one of our attorneys did develop, had a long-standing relationship with a person, I don't think that attorney would be willing to say, I'm going to give up my job over it. It just doesn't make any sense.
Counsel, we didn't talk about the authorized representative of the patient
Sure.
provision. So I just want to ask you, what is MHLS's position as to the scope of this authority, of that person?
In terms of, we're an authorized representative of the individual if they select us in that capacity. We have it flows from our enabling statute
You
article.
have the right to make consent to things on behalf of the patient?
No, that was a finding that the appellate division made, that we would have to be a person that could make decisions on behalf of our client, and that's not required by statute, and it's not in the legislative history.
Well, that's what I'm saying.
either.
What's the scope? What's the point of this person?
It's authorized representative. I think that the term can be considered synonymous with lawyer in a lot of respects.
But if you look at the legislative history, it used to say that either the patient or the authorized representative could attend and consent to treatment, and then it, so wouldn't that be an indication that it has to be somebody with that legal right?
I wouldn't concede that point. I would concede that our status as significant individual is probably the stronger argument in terms of 2913, but I'm not willing to give up that we serve as authorized representative as
The authorized
as well.
representative, according to the statute, right, it says that person shall be interviewed and provided an opportunity to actively participate, which potentially could be, even if the patient doesn't want them, although it seems that the team might not want that person in the room, but nevertheless, the statute does say that they must be provided an opportunity to actively participate. What's MHLS's position if you have the situation where the patient doesn't want you in the room? Under your theory, you've always got to be in the room.
We wouldn't go. No. If a client didn't want us at a meeting, we wouldn't attend the meeting. I think we would like to. Our position is that we can attend under Article 47. If the client doesn't want us there, we're not going to attend. But we need to have the ability to attend in our agency capacity, because there are individuals that are so disabled that they're unable to select us as their significant individual or authorized representative. And I would just point out to the court that the appellate division's holding is not limited to secure treatment facilities. It's a pretty broad brush interpretation of our enabling statute. And I would submit that if we are unable to attend treatment planning meetings in all other mental hygiene facilities, it would be a disaster in terms of MHLS and how we're serving our clients. We go to treatment meetings all day throughout the state. And I would ask the court to exercise caution when interpreting our statute because it is pretty...
But your other concern is that if you could be in the room, so long as you didn't wear the hat of the lawyer, you have to give up that role, that you just don't have the resources to do that.
We don't have the resources, but I also think that's almost a fantasy scenario, that someone would give up their ability to serve as an attorney to be a significant individual to a patient.
Well, that's not the way it's meant. I think it's meant in a particular case, you would recuse from that particular case and act as a friend, not that you'd give up your job in MHLS.
Thank you, counsel. Oh, excuse me, I'm sorry.
Respectfully, I just don't see it happening.
I see.
Thank you very much.
Thank you. Excuse me, Judge.